right, guys, on this segment, we're going to be talking about when should I trademark my business name. I say always, right? There's some businesses maybe you don't want to trademark, but in my opinion, every one of my businesses has been trademarked and it's worked wonders. And it's worked wonders to the point where I've trademarked the name, I've trademarked certain terms that are used in the name, put the copyright logos and all that on my websites on every page. The reason being is you are warning the public that you have an intent to claim this as your work of art, as your creation. Now, trademarks are very inclusive, and I will tell you this, not every trademark gets accepted the first time around, and there's different methods to get a trademark. You can try to do it yourself, which I've done a couple myself. I put the time, the effort, the resources in learning about it and the knowledge into it. Took a little bit longer, but I did get those trademarks in. Now, with an attorney can do it. They can draft it for you very simple. They'll have a series of questions, and ultimately they get you through to the finish line. And the way the USPTO, which is the U.S. Patent and Trademark Office that handles trademarks and patents, the way they look at it is going to be like this. Attorney submitting it, we're going to take this guy serious, boom. We're probably going to take that faster than Joe Smo, who doesn't have any experience. If they're probably understanding that's going to go back and forth a few times, right? So with that said, what is a trademark? Legal protection for business names, logos, or slogans. That's what it comes down to. Certain names cannot be trademarked. Certain names can. Trademarks are going to include a couple of different things. They're going to include colors. They're going to be including certain design marks. They're going to be including certain things on how you design it, what it looks like, what it says, how you capitalize certain letters, all this stuff, right? Now, there's definite tricks to doing this. Maybe I shouldn't say tricks, but there's advice to give on doing this, and we'll cover some of that later, right? Because after doing many trademarks, certain things will get rejected. If it's too ambiguous, if you're trying to trademark the term sidewalk, it's not going to happen because everybody uses that term. That means if you trademarked it, everybody else would have to stop using it. The other thing that's involved with this is, can a certain name be trademarked in a certain industry, but that same name in a different industry can have also a trademark as well? The answer is yes, because how they look at trademarks is this. You're going to trademark a name where it says, if somebody else had this name in the same industry, would this create marketplace confusion? Is in general the term that they're going to look at. If somebody else has a name and they try to trademark it and it's close to yours, which is already trademarked, or they use a name that's close to yours and you already have a trademark, you can tell them to cease and desist, to stop using it. And guess what? They will have to do that under the law, or you can take them to court. And I know because I have been at trademark court at the federal level. Not fun. You don't want to go there, and it can cost a lot of money, not only in attorney's fees, but in damages should you do things wrong or require you to change a lot of things on your business. Everywhere you have the mention of this name, everywhere in your marketing materials, any logos, prints, anything, it's drastic. Get it right up front. It'll save you down the line. So why trademarking matters, other than what we just talked about, right? It prevents others from using your brand. Simply put, why would you want to have your name out there and then later on somebody comes up and they start a similar business and they use something that is similar to your name? That would be very harmful because it creates confusion in the marketplace. Well, in a perfect world, you could just contact them and say, hey, you're using our business name. We would appreciate it if you don't do it. You're in violation. And then they would probably turn on and go, in violation of what? If you have a trademark, you can send them a cease and desist, which is a legal notice that says, we are putting you on warning. You have to stop doing this because as of today forward, if you do not stop doing this, or whatever time frame you put in the cease and desist, then they are now in violation of the law. And it comes down to that. Very simple, right? It protects intellectual property and brand reputation. Number two, why trademark matters. It protects intellectual property and brand reputation. You're here to build a brand. I would hope so. A lot of people don't want to build small companies and then change their names later on. A lot of people do, and they're idiots for doing that. I'll tell you that because look, if you're trying to build a brand and you want your name to stick and you want all the effort and the time, resources, and efforts that you put into growing this brand, why would you ever want to change your name? Your name, your logo, your trademark, your URL website online, all of that matters. And the longer that stays around, only the better that it can do. You buy a Nike shoe because of the brand behind it. That shoe's probably $5. You could buy that shoe for $10 somewhere else, but you pay a lot more because it's the brand behind it. The same thing with Chanel, Louis Vuitton, all this other stuff. You're paying for the brand. Think of it in brand, right? Number 3, when should you trademark? Immediately if you're planning significant branding or expansion. Every company I've come in, whether a business consultant or started my own company, trademarking is in the first 10 steps that I'm doing with that business. Of course, getting the documents together, the EIN stuff together, everything else, but trademark is in there. I have an attorney, $300. It's a full process. I already know the questions and answers. I just answer all the questions that they ask, and then boom, it goes in. Now, to get a trademark, you want to back up. You want to probably get a black and white mark first, and then add the colors to another mark or add it later on, right? Because you want the biggest ability online and the most reach so that somebody can't just do something a little bit different and then perhaps try to get away with it. Keyword try, right? So early stages for unique competitive names. If you have a brand new name, I have certain names in my business that have 2 words put together and ultimately certain letters are capitalized. Well, that alone became a search term online. People would start using my brand name and my company name in their search terms to get ranking on videos, to get ranking on social medias, on any marketing materials online or any marketing efforts. Guess what? I find that out, I'm able to send them a cease and desist and they have to stop, right? When pop sockets was big, I was selling pop sockets online. The actual trademark pop socket and patent from the pop socket holder. He goes on Amazon and literally they hit everybody with trademark infringement and patent infringement, and every listing gets shut down except his listings. What happens? He makes more money. He stopped it from fucking happening, right? It made it super easy. He said, look, these guys are infringing. We're not gonna have this. They're violating. Those listings got shut down. He's the only one. He gets all the sales. That's why you do it. You have to protect your brand identity. What happens without a trademark? Number 4, risk of another business using your name and legal battles over ownership, right? If you're the business owner, you have to prove that you're the business owner. You trademark the name. Intellectual property is its own thing. I have companies that I have intellectual property owned by other companies, and so ultimately my companies operate. They pay a royalty to this intellectual property owner that owns the trademark and the patent and everything else with my other companies. Amazon does it, Google does it. You know, every time an Amazon transaction happens, there's a royalty that gets paid to an offshore company from the US, and ultimately those royalties stay in that company. And every single product can charge that or pay that out, however you want to look at it, because they're using the Amazon name, which is owned by a third company. If you're using the businesses here, it's a very wonderful space to be because you can definitely use their advantage. There's many tiers and many levels to this. That teeters in the middle, the high level of understanding of businesses. All different information. If you want more information on that, put that a message down below, and I can definitely get you more information. Offshore accounts, trusts, trademarks, patents, intellectual property. It has another company owns all the intellectual property, all of that stuff. It's there. Ask me for it and I'll get some to you, okay? So look, process of trademarking. Steps, research. Number 1, you're gonna wanna research, or the lawyer's gonna research for you. Is this violating any other mark? Is it violating anything else? You know, can you say American? Probably not. American Airlines got away with it because they've been around forever. Certain things in California, like with marijuana, and I know this from directly being involved in it, you cannot say that something came from Humboldt County or California or have that in your name if it actually didn't do it, including your trademark. So these are things that you have to look out for. Other business names and trademarks that you're probably not able to do are certain professional items, you know, doctors or associations or anything like that. There's going to be limitations. Check with a lawyer on that, right? But what you're gonna do is you're gonna research. The lawyer's gonna research. They're gonna file. There's gonna be an examination period from USPTO. They're probably gonna come back and say, hey, you need to change this, or you need to clarify this, or you need to make amendment on this. Normally, a lawyer will be better at this. There's also people online, believe it or not, that have way more patterns under their belt and occurrences of filing trademarks than certain lawyers. For instance, my patent facilitator, not an attorney. I looked at attorneys, $10,000, $20,000, $50,000 for a patent. I did a $5,000 patent with this guy. Why? Because he's from India. He's filed over 5,000 patents when all these other people have only filed 200, 300, 500, maybe 800. So he has more of a pattern recognition on what's accepted and what's not, and he has a valuable input, which we went big, we went ambiguous. We did have 3 revisions, so I think it ended up being upwards of like maybe 6,000 or 7,000, but definitely beats $10,000, where now we're coming back, we're having to change it or go so specific on a patent that ultimately somebody else could copy it, right? We're getting off trail here, but this is the frame you need to look at this. There's other people that are registered agents that would be able to file trademarks for you or patents for you that have a lot more skills under their belt and actually have a lot more occurrences of doing it than some attorneys. Check with an attorney though, right? And of course the approval. The last one's gonna be the approval. Once it gets approved by the USPTO, you will have to do maintenance on this every so many years. However, you wanna make sure that fees are paid, things are done, whatever they say, you do this, and any information you submit is public information, right? Tools, USPTO website, and obviously legal services. I talked about both of those. Now, the cost of trademarking. I gave you some cost here. However, things could be different. If you're having somebody design your logo, that cost is going to be involved and needs to be put into this as well. If you've designed it, if you're going after, now you can look at some research. You can go on USPTO website, browse around, search other names. There's the ability to do a name search. Google also has patents, I believe trademarks as well, where you can search on there. Look at the names, go on Google. I like custom names because of 2 reasons. I create names that are custom because the 2 reasons are easy to trademark, easy to have any patents that go along with that. Really, it's the trademark side of things. But also for marketing purposes, it's easy for me because when somebody searches that name online, I'm not competing with anybody else. No famous people, no other businesses, nothing. My business shows up and it runs the gamut. A couple of my businesses, you search for my keyword, no other businesses should be coming up, because if they do, they're infringing on my company name. It's as simple as that. That's where you want to be at in your space. That's why some companies spell their names weird or with letters instead of numbers, or they break things up or hyphenate or whatever they do. That's why. Unique names, we talked about that in an earlier section. Let's see here. So, common misconceptions. Trademark versus copyright versus patent. These are all intellectual property. They are all property that you created, you designed, and you are entitled to have those reserved for you and have nobody else infringe on those. Hence why you would file a trademark on a name, on a design, on a logo, on a certain name for a product, not just your business name, a name for a product. The proper use for these, if you are intending on trademarking it, put the TM next to it. You can use TM all you want. There's no right or wrong way to use TM. You have the intent to go do that and to trademark it, use TM. That shows somebody that you're intending to trademark this, right? When? Who knows? However, you cannot use the registered, the circle R with something or a logo on it if it's not registered and it's not trademarked, right? Because now you're in violation. And if you have a logo and you finally have TM next to it and then you finally get it registered on the trademark list, make sure, that you update and you put that R on it, the circled R for registered, because that is part of a logo. I mean, look at any FedEx truck, UPS truck, look at big companies. I mean, they even put it on the front where it has the R. You need to have that everywhere to let people know this is registered. And actually, another tip here is if you don't tell somebody that they're in violation, you are actually in violation of your own trademark notification rules, that if you don't notify somebody that they're violating it by infringing on your trademark, you could actually get your trademark pulled. So it works both ways. You want to make sure you're compliant. Tell somebody a cease and desist if they are going to infringe on your trademark there. Copyright is copyrighted information. Song, audio, text, website, anything like that. Web pages, they should all have copyright at the bottom. You don't have to register those. You're just letting people know that this is copyrighted information and they should not be duplicating it anywhere because it is yours and you created it. Patents, totally different. Utility patents, there's use patents, and then there's process patents. There's a couple different patents, right? I'm calling them different names. However, there's generally 2 patents. It's utility and I believe a process. Don't correct me on this. We could look this online, but at the end of the day, when you have a patent, it's about your invention. So patent is different than a trademark. The patent itself may have a certain product name in it, and that product name may have a trademark. Does it need to? No. Does a patent, a trademark that's in a untrademarked name in a patent trademark the name? No. You did not go through that process. You have to go through that process. You have to trademark the name first and then get it in the patent, or vice versa. You can have it in the patent and trademark it later. I'm just letting you know that there's no consistency there between the two, or relatability. One does not do the other. You know, if you have a patent for a certain process, but that process has a name, if you trademark it, that doesn't mean you have a patent on it. So these are independent of each other. Think of them as all three are independent: patent, copyright, trademark. Outside of that, make sure you protect yourself. We'll see you on the next one.